I'm Ellen Dorn, and I'm batting cleanup today. I have been asked to present to you on the legal aspects of dying, which I consider boring. The more boring, mundane documentation tools that you should have in your toolkit as you undergo the planning process that everybody before me and that I will tell you that you need to do in preparation for your ultimate death. I want to tell one funny story following Matt on your presentation. I don't know if you know this story or not, but in the course of Matt describing the Catholic Foundation, one of the things he said was, we were started 74 years ago because the Baptists had a foundation, and they were doing it, and somebody said, hey, Catholics, you should do the same thing. And I just want to tell this personal story. When I was about 30, returned to Dallas, my hometown, and began working for the Baptist Foundation of Texas. At that time, I was an Episcopalian. During my time there, I converted to Catholicism. And on the Friday, it would have been Good Friday, before I was received at St. Rita on an Easter Sunday, I received 24 red roses from Matt's predecessor, Bernie DiFiore, who was president of the Catholic Foundation. So the Baptists might have gotten there first, but the Catholics are killing them with love there at the Baptist Foundation. So. But today, I would like to talk to you about 3 different areas that I'd like for you to begin to consider. One is planning for your disability before your death. Most of us will have some disability, and you need to plan for that. You need to consider that that will happen in your life. The second, I will briefly discuss the disposition of remains. And finally, I will cover a little bit of the highlights of wills and probate. So to begin with planning for your disability before death, there are 3 key documents that you need to know exist, and you may want to have in place. There's one you're going to hear me say, I insist that you have in place, and 2 that you might consider. The first is the durable power of attorney. This is a document whereby you name who can handle your financial affairs during your lifetime if you become unable to do so. In Texas, we have a statutory form for this. What that means is that the Texas legislature wrote the form, for better or for worse. And it is a standard form used to name who can make financial transactions for you during your lifetime. It's a very useful tool if you have a person or people in your life that you trust completely. If a person has your power of attorney, they have the legal authority to take any action they want that you've given them in that document. It's wonderful if you're disabled and you have a trustworthy person that can take those actions. Be wary, though, because they have a lot of power. And if you don't trust them completely, that is a source of abuse. Just so you know some of the legal terminology with a power of attorney, if you have a power of attorney, are called the principal. And the person you name in the power of attorney to act on your behalf is called the agent. And the agent has a very high fiduciary responsibility to you as the principal to do what is in your best interest. But of course, if a person is acting under your power of attorney, then that means that you're not able to act, so you can't really monitor them. So again, name somebody that you trust. Sometimes, if you have some hesitation about who could I really trust, or sometimes in families there's conflicts. For example, maybe there's some sibling disputes, and putting one sibling in charge of helping you with finances might cause eruptions from the others, something like that. Sometimes just simply having a joint bank account with a trusted person, a trusted child, might be all that you need to make sure that the bills get paid if you're not able to pay them yourself. The second disability planning document that I absolutely recommend, it is the document I recommend more than any other, is the medical power of attorney. This is a document where you name the person who can make medical decisions for you during your lifetime if you can't do so yourself. It is absolutely essential, I believe, that when you're in the hospital or when you're sick, that you have an advocate who is looking out for you. And I know there are many doctors in this crowd, and they may, I hope, agree with me. In my experience, doctors really want this. If a doctor has a patient in the hospital and there is no advocate there, the doctor's going to do their best to look out for that patient, but it's hard. And it's hard to know what they really want. They're sick. They can't tell you. An advocate can speak for you and look out for your interests, can knock on the door, can make the calls, can push for the care, rather than let you languish when you're sick. So I strongly, strongly urge, thank you, that medical power of attorney. In Texas, the medical power of attorney is a statutory form also. And in the statute, it says that you really should not make many modifications to the form. In other words, the statute says, don't go be creative and come up with something new and fancy for this, because we want the hospital and the doctors to recognize the form so that they know they can acknowledge it. However, the Catholics have fiddled with the form just a little bit. And as I tell you a little bit more when I talk about the directive to physicians, it is promulgated here in the diocese and in Texas with the Texas Catholic Conference of Bishops, a Catholic medical power of attorney. And essentially, it takes this Texas statutory form and adds some directives within that, simply to put the doctors and the medical staff on alert that you're Catholic. And here on this slide, I put down what the different Catholic language is that I will use when I have a Catholic client who's wanting their documents to reflect their faith. The first point is real simple. Hey guys, I'm Catholic. I belong to the Catholic Church, and I direct that my healthcare decisions be made in accordance with Catholic teaching. The second, I direct that those making decisions on my behalf be guided by the moral teachings of the Church. I direct them to consult my priest, my bishop, or the National Catholic Bioethics Center. This point that is in these Catholic documents that are promulgated in Texas is exactly the point that Dr. Thompson was making earlier. In fact, you'll find throughout this presentation I will refer to her remarks because she said beautifully so many principles that we try in a much more inferior way to put into writing in our documents. But basically, what you would say in your Catholic medical power of attorney is, go get help. If you've got an ethical problem and you don't know what's Catholic, reach out to those who know better and seek help. The Catholic medical power of attorney also has an option on some language. One option is to say that I executed an advance directive, that's commonly called a living will, and I'd like you to pay attention to that advance directive when I am nearing the end of my life. And I'm going to get into that advance directive in just a minute, so I'll get into the details on that in a little bit. But that's one option, is you can say in your medical power of attorney, hey, go look at my advance directive. But another option is you can say, I direct that the agent who I've named in this document, the person who's going to make medical decisions for me, I specifically grant that agent the right to make end-of-life decisions for me. And there's a specific provision in the Texas statute that allows you to direct that agent to make those decisions. And I will tell you that in my practice, I'm blessed with a number of wonderful, faithful Catholics. And among all my clients and among this group of faithful Catholics, I would say it's about a 50-50% of who chooses what. I have, one group of clients will say, I absolutely want a living will that describes the kind of care that I want when I'm dying. And typically, that group of people will be ones who will say, who when they do a living will, and again, I'm going to describe that in a minute, but they'll say, take me off of life-sustaining treatment. Pull the plug. I don't want any life-sustaining treatment if I'm dying. A person who will say that typically very much wants to execute that document because their thinking is, it's completely legitimate, I don't want my loved one to never sleep again. I don't want my loved one to be put in the position of having to make a life or death decision for me. I'll tell it to them right here. It's okay to let me die. let me die. I want to put it in black and white. That's one way of thinking, and many people have it, and you can be a good and faithful Catholic. I'll let the theologians, Bishop Kelly, address that when I say it wrong, but generally, it's morally licit to sign an advance directive. But there's another camp of people who think about it completely differently. And that camp says, I don't know when I'm going to be near the end of my life. It could be because when I walk out of the room today, I get hit by a Mack truck on the way home. And my life has suddenly changed, and I am near the end of my life today. Or it could be that when I'm 98 or 99, and my body is shutting down and I'm approaching a natural death, that is when the end-of-life decisions are being put before us. And because I don't know, I can't sign a document today that tells you what I think should happen to me. And instead, even though I love my agent and I don't want that person to feel burdened, I also love that agent and know they're going to do their very best for me. They know who I am. I have communicated with them and told them how I feel, and they will be boots on the ground for me, being my advocate and my decision maker when that time comes. So I just want you to know there are two ways to think about it, and I see clients go down both paths, and in my judgment, it's a completely personal decision as to how you approach that. Now, this third document then that I want to discuss in some more detail is this directive to physicians, or often it's commonly called a living will. In this document that you can sign, some do, some don't, you state your preferences for your medical care in the event of a terminal condition or an irreversible condition. And the terminal condition is defined under Texas law. And a terminal condition is a condition where a doctor has diagnosed you in writing with an illness, and it is anticipated that you will die within 6 months. An irreversible condition is a condition under Texas law, it's defined, where you are being kept alive on some kind of life-sustaining treatment. That's another defined term. And it is known and understood that if you are taken off of that life-sustaining treatment, that you will die. So in the irreversible condition, it's possible that your life may be sustained beyond that 6-month period, but it's solely because of a life-sustaining treatment. And a directive to physicians under the Texas statute, the contemplated living will in Texas says that if you're in a terminal condition or an irreversible condition and you are not able to make decisions for yourself, then the document controls how your care shall be, what kind of care you will get. Under the Texas statutory form, the format is rather stilted, in my opinion, but it basically says, if I am in a terminal condition, either A, checkbox A, take me off of life-sustaining treatment, or keep me on life-sustaining treatment. And then you go to the next section, and it says, if I'm in an irreversible condition, A, keep me on life-sustaining treatment, or B, take me off of life-sustaining treatment. It's a very, there's not much nuance in the statutory form. It's a check the box, pull the plug or don't pull the plug. Well, what is life-sustaining treatment? Here on this long slide that I won't read with you in detail, but that is what I put here, is the Texas definition of life-sustaining treatment. And it's basically treatments that are keeping you alive. But what I think is very important to note in the Texas statutory definition of life-sustaining treatment is artificially administered nutrition and hydration. Dr. Thompson talked about this earlier, and I'm going to talk about it some also from a legal standpoint. The reason that's important to note is that we as Catholics don't think of hydration and nutrition as something extraordinary that should be withheld from a patient when they are dying. And so it's important to note that the Texas statutory definition of life-sustaining treatment includes artificially administered nutrition and hydration. In other words, a feeding tube or intravenous fluids even though from a Catholic perspective, we might call for those to be continued. It's a conflict. There are some problems with the Texas statutory form. One, I just said, this artificially administered hydration and nutrition shouldn't be called a life-sustaining treatment. As a lawyer, there are a couple of other problems. The statutory form comes with a narrative that explains it before you get to the legal form. So the statute writes an explanation of the statute. And the statutory explanation explains the statutory form incorrectly. And in addition, in the statutory form itself, it'll kind of summarize what another portion says, and it does it incorrectly. So the Texas legislature shouldn't be writing this many words for a legal form. And the other problem that I have with it is that there's a line in the statutory form that says that it is presumed, a do not resuscitate order is presumed to have been signed with the execution of this document, which is very ambiguous. And I think as Dr. Thompson explained earlier, a DNR says, don't provide cardiopulmonary resuscitation to me. And when a person is sitting in my office signing a living will, they're not ready to say they don't want CPR. So it should never be interpreted in that way. And I think that's a problem with the document. It's a little bit stilted in its yes or no, A or B structure. And the other thing I will say is that the vast majority of people who come to my office will sign one of those and will check the box that says, take me off of life-sustaining treatment, pull the plug. I would say probably 90% do that. There's nothing wrong with, again, I'm not telling you it's a morally illicit choice. Dr. Thompson went through, I think was very clear in her beautiful explanation about there are times when I wrote it down and now I don't have it in front of me. She had some beautiful language to the extent that life is a good, but it is not a mandatory good, or something to that effect. There are times when it's okay to let go. But it is certainly licit to select the take me off of life-sustaining treatment option. But do we need to always put the question to young, healthy people in that light? Do we need to ask them today, when you're up and about and running around and sitting at a conference on a Saturday morning, do we need to make you make a decision now about exactly how your care will look at the end of life? I'm not sure we do. Another concern, some other concerns with the statutory form is that they conflict with Catholic teaching. With the food and water, as I mentioned earlier, life-sustaining treatments include routine medicines like blood pressure medicines. An irreversible condition, it's broadly drafted and, as I mentioned, not linked to your imminent death. If you can imagine a kidney dialysis patient, well, some kidney dialysis patients go about their daily living and cope just fine with that burden of that dialysis. But under this Texas statutory definition, that is a life-sustaining treatment that would be withdrawn if that patient becomes unable to make medical decisions for themselves. Well, should it? Not so sure it should. And also, it's very important that in the absence of an advance directive, there's no presumption that a person wants life-sustaining treatment. So if you don't have an advance directive or a medical power of attorney that says otherwise, a hospital doesn't need to presume that you would want to be kept on life-sustaining treatment. That's of concern. So I mentioned earlier, and in your materials, it mentions that there are some Catholic Texas medical directives. And I want to tell you a little bit about the history of how those came to be. When now Cardinal, then Bishop Farrell was here in the Diocese of Dallas, he had come from the Archdiocese of Washington, D.C. And when he had been there, he had worked with the Maryland bishops and the Maryland lawyers. And the Maryland lawyers had put out Maryland medical directives consistent with Maryland law. And then the Maryland bishops put out a pastoral letter about end of life, death, and dying. And in an appendix, put the lawyers' forms in the back. And he liked that. And so he came, when he got to Dallas, he said, hey, I'd like to do that. And he put together a committee of lawyers from the St. Thomas More Society, which is the Catholic lawyers group. I was part of that committee. And we developed Texas Catholic medical power of attorney and directed to physicians. In the course of doing that, we consulted with many doctors, some of whom have been here today, Dr. Hine, I don't see him now, and Dr. Peterman, Mr. Dr. Peterman. And we worked with doctors, we worked with the National Catholic Bioethics Committee, and we put together this Catholic form where we took what was valid in Texas law and attempted to overlay it with Catholic language for the Catholic Texan. So what I'd like to do now is kind of walk you through what is in that Catholic directive to physicians. The first few are exactly what I showed you in the medical power of attorney earlier. The first one says, I'm Catholic, treat me like a Catholic. And if you don't know what's Catholic, talk to my priest, talk to my bishop, or talk to the National Catholic Bioethics Committee. Number two, I direct that those making decisions on my behalf consider only the quality and effectiveness of the proposed treatment and not make any judgment about my quality of life. This speaks to what Bishop Kelly addressed to us first in the morning and also what Dr. Thompson addressed, that we as Catholics don't think there is such a thing as a quality of life that deserves death, that suffering at all stages is okay. Not easy, but it's okay, and it is not to be terminated just simply because there is suffering. Now, if you got a treatment that's not very effective, that's another matter, but the quality of life is always sacred. The third directive specifically addressed artificially administered nutrition and hydration. And I will show you, I didn't put the full language in here, and I'd like to explain a little bit what this third directive says. It's very long, it's very mumbo-jumbo, and it has words in it that I can't pronounce. They're medical words like subcutaneous and other things that I can't say. But I want to tell you what it generally says and why we use the language that we do. Generally, the third directive says you cannot treat artificially administered hydration and nutrition as a life-sustaining treatment. If I say take me off of life-sustaining treatment, I am not saying take me off of food and water. But then it goes on to say, unless, with all this fancy language, my body is rejecting it because I'm in the course of dying. And the specific language in the directive was, this Catholic directive, comes from the Texas statute in another place. So Texas has a statutory form for an advanced directive that says it's okay to take away food and water. But in another part of the statute, it says that if a hospital wants to take a patient off of life-sustaining treatments, there's a process that the hospital has a right to do that. But if the hospital has jumped through that process and has a right to do it, since 2015, it has not had the right to take a patient off of food and water unless the body is rejecting that food and water. So in 2015, the Texas legislature adopted some language that was a carve-out exception for when a hospital was permitted to remove food and water from a patient. And it has to do with basically when the food and water is doing more harm than good. And those of you who are physicians here can speak to those kinds of situations much better than I can, but we do know that when a person is near death, food and water can, at times, become damaging. Well, Dr. Thompson told the story about her cousin and the inability of her cousin to process the feeding tube food, nutrition that was coming to her, and they took her off. That was a perfect example of that kind of thing. The last directives in the Catholic Directive to Physicians says, no drug or lethal injection may be given to me for the purpose of or with the intent of hastening my death. Don't kill me with morphine, please. And it says, palliative care, as defined below, shall be provided to me until I die. And palliative care, is defined in the document using a definition that is in use by the National Catholic Bioethics Center. We also include language that says, please find a Catholic priest so that I can receive the sacraments. And then we also we very bluntly counteract the statutory presumption that signing this document authorizes a physician to sign it out of hospital do not resuscitate order. So we're saying there may be a reason to sign a DNR, but we're not saying just by signing this document today in a lawyer's office that that's automatically a reason to sign a DNR. Okay, so that concludes the first part of the presentation I wanted to give about how to plan for disability during your death, how to plan for disability during your lifetime. A very quick mention of issues related to disposition of remains. I simply wanted you to know that it is possible in Texas to donate your organs through a registry called the Glenda Dawson Donate Life Registry. An alternative to that, if you're interested, they are either or, they are not, you can't do both, is you can will your body to science. In this area, UT Southwestern is the willed body recipient, and they have a program, I've given you the website there, whereby you can will your body to science. That means that your body would be used perhaps as a cadaver in a medical school training or in some other means of research. The Southwestern takes the body free of charge, ultimately cremates the remains, and offers to either return them to the loved ones or to inter them in a garden at Southwestern. Finally, I'd like to address wills and probate. I'm going to go through this with a very bird's eye view, and if you don't come away with the message that you need a will, then you weren't listening at all. If you do not have a will, the Texas legislature decides how your property passes at your death. And it's complicated, and I've never met a single person who wants their assets to pass the way the statute says it would pass. Under the Texas statute, land passes to different people from your financial assets. A single person's property passes differently from a married person's property. If you're married, your separate property, meaning the property you inherited or brought into marriage, passes differently from your community property, meaning the property you acquired during marriage. So it goes in all kinds of weird directions. And in addition, if you die without a will, it is an expensive and time-consuming process for those who love you to deal with to get your property that survives you out to the heirs you want them to go to. Also, with a will, you can name who you want the guardian of your children to be, if you have minor children or disabled children. With a will, you can establish trusts for a wide variety of situations. If you have a child who is an addict and you know it would be bad for that child to come into a sum of money, you can set up a trust so that the money is there for that child but not going to be burned through addiction, or an illness or a disability, or a special needs, a learning disabled child. Trusts are wonderful vehicles for entrusting the management of money to someone who loves a beneficiary who should not be entrusted with managing the money themselves. You can, if you have a company, if you have a special land, a vacation home, other specialty assets, you can provide instructions and make sure that those assets are dealt with after your death by people who are going to be stepping into your shoes who've never dealt with the assets before. One misconception that many people have is that probate is a bad word. And in Texas, it's not really true. Probate's a pretty simple process if you have a will. Now, if you don't, it's a pain. But if you have a will, probate is simply a process whereby a lawyer takes a will to the judge, and the judge does two things. It says, one, yes, this is a valid will, and two, the person named in the will has the legal authority to step into your shoes and transfer title to the people named in the will. And it's a pretty routine process if you have a will. If you don't have a will, it's time-consuming and expensive. Trusts, there are many people, and there are many very fine estate planners who have a different perspective on this than I do. But many estate planners routinely will have people set up a revocable trust and put all of their assets in a revocable trust during their lifetimes so as to avoid this big bad probate at their death. I don't normally, in a routine situation, I personally don't do that, because what I find is people spend a lot of money to set up a trust, and then they have a life and they go on and they live for 10 or 15 or 20 years and they buy stuff and they sell stuff and they inherit stuff. And by the time they die, the trust doesn't have much in it anyway, so it didn't do a whole lot of good. So that's why I'm not routinely recommending them. But if you own property out of state, or if you have disabled children, or if you have mineral interests, even if they're in state, those things can often be very good reasons to establish a trust during your lifetime to hold those assets. And another good reason to use trusts is tax planning. I'll get to tax planning in a little bit at the end. You also need to be aware that not everything you own is governed by your will. Your IRAs are governed by the beneficiary designation that you put on the IRA when you set it up. If you say your estate is the beneficiary of your IRA, then it's governed by your will, but you don't want to do that because you have bad tax problems if you do that. It's much better to name individual people as the beneficiaries of your IRAs. Life insurance, you will often name people instead of the estate. They go to the people you name, not according to your will. In Texas, it's possible to set up your real estate, your home, with a deed that names the beneficiary of the home at your death in the deed records of Dallas County. And if you have such a deed, they're pretty rare here, but you can do it. Then your will doesn't control your house, the deed does. So when you meet with an estate planning lawyer, what they will do is they're going to want to get their arms around all the assets that you have, and they're going to want to figure out what is probate assets, what assets are going to be controlled by the will that attorney's going to write for you, and what assets are not going to be controlled by the will. And if they're not, how should those beneficiary designations be changed so that it jives with your will and makes a cohesive plan? And finally, I wanted to address federal estate tax. Just a very mini lesson. We have a federal estate tax that right now is imposed only on extremely large estates. In 2024, I think if you die with an estate of $12.6 million or less, you will not need to meet the tax man at your death, which is huge, and most people don't come anywhere close to that. It's over 13 million now. I mean, it's so big, I don't use the number every day. It goes up a little bit every year, and so in 2025, the number hasn't come out yet, but it's probably going to be 14 million. That's all well and good, and you can think that's of no concern to me, but what you need to know is that on January 1, 2026, the federal exemption is going to get it cut in half to, let's call it 7 million. And you might think, I don't have 7 million, what are you talking about? Most people don't have 7 million either. But what I want you to know is that you might, and some of you might have more than you think, because your federal estate, for tax purposes, consists of your home, life insurance. Of course, you're not living off of any life insurance proceeds right now. You don't think of that as something you have, but you might have life insurance, and all of your financial assets, including your retirement assets. So some people, it's still quite a large sum, but there are people who are in a position where they might have a taxable estate at their death. And an estate planner will want to figure that out and want to help you create a will that minimizes the impact of those taxes at your death if you are in that situation. The estate tax is high. It's 40% over that exemption amount. So it's worth some planning if you're in that category. And I also will say, to follow on the presentation immediately before me, from a federal estate tax standpoint, any asset you give to your surviving spouse avoids estate tax in your estate, but lands in instead you put it in your spouse's lap for when that spouse dies. And additionally, any asset that you give to charity avoids this federal estate tax. So that's a very key estate planning measure when a person is looking at federal estate tax. And that's what I've got today. I'd be happy to answer any questions.
Ellen. Ellen, with regard to durable powers of attorney, do you recommend that your clients take those to, particularly, say, a financial institution that has a lot of their money, and make sure they're acceptable before you ever have to use them?
Great point. So I mentioned earlier that Texas has a statutory form. The Texas legislature wrote a form you can use to name who should manage your financial assets. But you know what? Every bank and every brokerage firm in town and around the nation has their own lawyers. And especially if you think about Fidelity or Vanguard or these major brokerage houses that are based outside of the state, they don't really care that the Texas legislature wrote a form, and they typically have their own form. So what I would say is, what I recommend is if you have a lot of assets at a particular brokerage firm and you want your child or your spouse or whoever it is to be able to make decisions for you with respect to that money, go ahead and get the standard statutory form, but then go to that brokerage house and say, could you give me your form, and sign their form too. Good question.
If you have an advance directive to physicians, do you file that with your healthcare providers at the time that you execute it? And what happens if you're not part of Baylor, Scott & White, or you're hospitalized outside of that network?
That's a great question. There's no requirement that you file. There is no standard filing procedure. But what is very common is when you check into the hospital, they will always ask you if you have a directive to physicians. And I've seen not only will they ask you that, but if you say no, they're very often, if you're in for serious surgery, going to suggest that you get one and show you the statutory form. So my recommendation would be that you do it, and that when you go into the hospital for a significant procedure, that you take a copy of what you've done with you and give it to them.
Hello. Probate. Tell us a little bit about that in terms of public information. Is this, I know in some countries they publish it on the front page of the newspaper. Joe Smith passed away, he was worth X. In Texas, is public, they say it's public information. Is there a way to avoid it? Why would someone want to avoid it? If you could speak a little bit about that.
Great question. Okay, so when you probate a will, what you do is you file an application and the will itself in the public record. So when you probate a will, the will does become a public record. So for that reason, I guess there are two sides about the will itself. I tend to encourage people not to put, I give my Hope Diamond to my friend Sam Shepard, who lives on Mulberry Street. I don't want to get specific about what the assets are, because that becomes a public record. But it is important to know that if you don't do a trust, and I disparaged those living trusts earlier, but this is one advantage of them. If your will says, I give to my children, it's going to name those children, your wife, your neighbor next door. If you want to disinherit somebody, which sometimes people do, I never think that's a real great idea, but if you do, you've got language out there, your parting shots in there in the public record. I don't want my son Joe to get a dime. And there you have it for eternity. So the will is a public record. And then you go through the process. You file the will, you wait a period of time, and then you schedule a hearing. You have a hearing where you offer testimony and the judge ascertains that it's a valid will. Then the next two things that have to happen are you have to publish a notice to creditors in the county where you're probating the will. So any creditor can see that you're probating it, and they are given the name and address of the executor. I always use my office address for the executor, so the executor's home address is not in the public record, but there's the name of the executor and the way to contact the executor that's out there. And then 90 days after the hearing, the executor has to prepare an inventory of all of the assets that the person owned. Up until about 10 or 12 years ago, you had to file that inventory in the public record. So if you're Ross Perot and you've got it, it's all in the public record. That's which genealogists love. My mother's a genealogist, and I've got inventories from people from 1910 in my family. So it's kind of it's really quite interesting to see. But nobody likes that. And today, in today's world, about 15 years ago, the law changed, and what is now the law is that the executor is required to prepare an inventory, and if certain basic criteria are met, like there are no outstanding creditors is a key one, what the executor does is gives that inventory to every beneficiary of the estate, and then files an affidavit in the public record that said, I put together an inventory and I gave it to everybody that matters, and I'm done. So that the actual assets only are known by those who are beneficiaries of the estate.
When you're saying inventory, you mean assets, stocks, bonds, land, houses?
Correct.
And when you say public information, can I go on my phone and see Joe Smith passed away 2 years ago and pull up his
You can.
probate?
You
It's
can.
that easy. So you sort of do want to avoid it if you can, I would think. So people don't see your inventory,
Well,
your
obituaries
assets.
are typically public information. So the fact that somebody has died and the date of their death is typically not. It could be. If it's certainly possible if that's something that causes concern. You can certainly avoid having that in the public record with the
So
trust.
the last question, I promise, is like you mentioned Ross Perot. Can someone go on and see all the assets and all the stuff he owned before that law passed? And would that happen today?
Yes, they could have on a wealthy person that died. Today, people avoid that by simply giving it to the beneficiaries of the estate. Yes.
I had a question from earlier about the disposition of remains as it comes to donating organs or the like. I had heard in previous years about things like organ harvesting and stuff like that. Is there any kind of statements in these documents about, that would kind of protect from things like that, or make sure that you get all the care that you're supposed to have, and or if you are interested in becoming an organ donor, do you need to write in something like, I'm offering my organs, but not for purposes of blah, blah, blah?
Great question. So in the documents that I talked about, the directive to physicians and the medical power of attorney, we do not specifically address organ donation. The way it is addressed is it says, I'm Catholic, and if you need help in knowing what's appropriate, consult someone that you know. So we don't get into the weeds about the particular issue, but what a Catholic with those documents is saying, please ask the question. And in the organ donation registry in Texas, I would have to say that it is an all or nothing. I do not believe there is a free-form opportunity. It's a database, and I don't believe there's a free-form way to express that. Bishop Kelly, I don't know if you want to speak to, there are definite issues in organ donation. I know the church says it's licit, but you're asking a question that's very on point. Even though it's completely licit, there may be circumstances where organs are harvested before the individual has died, and that's certainly problematic. Bishop Kelly, I ask if you can address some of the moral issues on that.
Yeah, I don't know. I don't know anything specific about that. I just know there's some kind of checks and balances in the system to make sure that that's not happening in terms of who's making the decisions about it. But I don't know the specifics of it. I would have to look that up, yeah.
Yes.
Yes, I have two questions. You mentioned that no drug can be given to hasten death. However, can you advise us on maybe from both the medical and legal perspective, how that should be addressed in our directive? Because I've witnessed several instances to where it's cloaked. They want to give an injection to help them with their breathing or to reduce the oxygen requirement of the organs. And in all cases, it's left to basically death by that evening. So is there a way that we could address that in our documents?
The document states the principle, which is that if I'm in pain, it's okay to give me pain relief. but not that hastens my death. So that's the principle. The execution of it's much more traumatic and difficult. I can't give you, you don't want my medical advice, but Dr. Thompson addressed it earlier when she mentioned looking at more closely at some of the hospices. And she said, I think what she said was that there are some hospices where it's kind of known that within 3 or 4 days, they're gone. That happened with my mother. It's very personal. But, and what she was saying was, be very vigilant, ask for dosages, ask very specific questions.
You know, I've questioned, you're giving an awful lot at very frequently. Are you not euthanizing? And of course, oh no. So it's really difficult.
All I can say is I agree. I agree. I don't think it's possible in terms of a legal document to spell out what's okay and what's not. That's way too variable and way too much too unknown at the time a document is signed.
Okay. Also, if a person enters the hospital and they have signed something like, I do not resuscitate, or I do not want artificial means, but yet at the same time, I guess that, you know, I think they're still able to make a decision and they're begging to continue treatment, and the medical staff just says, you don't know what you're talking about.
The directive, right, the directive to physician is null and void if the person can make a decision. But what that speaks to is what I said about the medical power of attorney. It is so important to have an advocate there for you, who's saying, hear what she's saying, hear what she's saying, this is what she's saying, this is what she wants, and speaking loudly for you.
Okay, thank you.
Hi. If I want to make a will, what are the requirements by Texas law? Because I see you can download things from online. I don't know if the medical advance directive, that's another question. Can that be downloaded, and how do I sign it, make it official? What do I need to do?
There are downloadable forms, and I'm a lawyer, I don't like them. I'll give you a few examples. So, well, to answer your question, the will itself, you have to be doing it of your free will, over the age of 18, unless you're in the military, before 2 witnesses and a notary. Those are the basic requirements. And you have to have the mental capacity to understand the general nature of your wealth and the natural objects of your bounty. You need to know generally what you have and generally who your spouse and children are. Is what the basics of what's required. There are online wills. Very often they have language that make them harder to probate. So again, the probate process is a process whereby a judge issues an order that says this is a valid will and this is the person who's in charge of executing the will. And what I've seen in online wills is that they fumble with the language about naming the executor. They'll use different language, and you have to, in the course of the hearing, prove that the language that was used in that will really meant executor. That's not so bad. But then what also happens is that they won't contain language about authorizing the sale of property, so that if there's a house or a land owned, often language is missing from that about giving the executor the power to sell that. That gets cumbersome. And then I'll tell you my favorite story. Sometimes what happens is they are signed, the signing process is fumbled. The law says you have to sit in a room with the testator, the person signing the will, plus 2 witnesses, plus a notary, 4 people. And they all have to be in the room together, all signing it all together. Everybody has to watch everybody else sign. And what my favorite story is that one time I was presented with a will that had been printed off online and taken to the beauty salon because this woman's mother-in-law owned a beauty salon, and I don't know what happened. I wouldn't dare to speak, but generally something happened where there were 2 signatures and a notary that all occurred in that beauty salon, and I was in the position of finding the people, some of whom were ladies getting their hair done, others were other workers in there, who were present, and I would say to them, like, were you all present in the room at the same time? I don't know, she was a nice lady, she came up and asked if I would sign this. And going to court and trying to prove that the circumstances that had occurred at the will signing was cumbersome and difficult. So, yes.
I have a friend who said she put her home in a trust to avoid probate. Is that something you would recommend, or is it necessary?
You can, and what would happen to that is, when she did it, somebody wrote a deed that conveyed it from her name alone to the trust name, and then upon her death, the trust owns it, and there's no probate, the trust owns it, and then it depends on what the trust says as to where it goes next. Does it stay in trust for the benefit of the kids, or does it need to be deeded out to the kids outright after that? So it can be done, and people do that all the time. One thing it doesn't do that sometimes people think it does is protect that home from creditors or other liabilities, because typically that trust is revocable, and a revocable trust doesn't offer that. But Texas has very robust homestead and personal property protections. So if a creditor is after you, or if somebody sues, they can't take your home. And then the standard is they can't take your home, your gun, or your car. The only people, the government can take it if you owe taxes, and the mortgage holder can take it if you have a loan on your house. But other than that, there's a certain limit on the house. Your homestead can never be taken from you, aside from the secured creditor or the IRS, and your personal property up to a certain level can't be taken from you either.
Ellen, we've got one more question, and then we'll turn it over to Kelly Halashin from the Diocese of Dallas.
Does your executor have to be a person, or could I make my financial institution the executor?
You can name a commercial trust company that's been given trust powers as an executor. When it's desired that an entity be an executor that's not a commercial trust company, the typical habit is to name an officer of that company. And then you would have to get, say, your financial institution to agree to that. So your financial advisor, Joe Smith with Merrill Lynch, could be named, but it's Joe the individual who's the executor.